Now we will discuss about the patenting process, how a patent is filed, how it is prosecuted, and how finally it is granted. Now let me tell you that a patent process is a very complex process wherein there are multiple stakeholders who are involved. The involvement of inventor, the agency which files the patent, it could be an attorney or a lawyer, and then the examiner, the patent office, and the prosecutor. So all these people are involved. I'm not going to tell you the exact legal process that takes place while the prosecution grant of patent, but I will briefly touch upon the process which is usually followed the patent offices worldwide. Normally, the start of the patent is by the filing of its application. Now here, the application filing. Now, let me tell you that a patent application could be of different types. So, normally world over, there are two types of patent applications that could be filed. One is provisional and another is non-provisional, or it is also called a regular application. Not in all countries, but in the US, in Australia, in India, and elsewhere, the provisional patent applications are valid. In Europe, there is nothing called a provisional application. So European patenting system is a little bit different from the US patenting system, and we are not going into the nitty-gritties or the details of these differences, but I will tell you the overall how the patent application processing is done. So normally, even before you file a regular patent application, so this I can say is regular patent application, or it is also called a non-provisional patent application. Even before that, you have a non-provisional application filing. Sorry, it is provisional. So regular is the non-provisional, and before that you have provisional. So when you file a provisional patent application, let us term it as the timeline 0. Okay, so normally within 1 year of the filing of the provisional patent application, you can file a regular patent application. So this duration is 12 months. I will take the timelines in months. So, and at this point you have the regular patent application filing done. So normally after 12 months this provisional application expires and you can no longer take the benefit of this provisional to convert it into a regular patent application. Remember that a provisional patent application is a shorter form of patent application. Here you do not need to comply by all the patenting drafting rules, so does not require lengthy patent drafting rules, and they are shorter and they require less effort. So when do you think this provisional application filing would be beneficial? It would be beneficial when you are not entirely ready with your invention, but you want to file it in order to get a benefit of filing it before anybody else files it. So when you do not have a very profound invention in place in detail, then you can file a provisional patent application for that. So you get 1 year of time to work on that, to work on an invention, and then convert it into a regular patent application, which should comply by the patent drafting rules. So you must comply by the patent drafting rules. It should have the required length, it should have required claims, drawings and everything, so that it is then prosecuted in the patent office. So prosecution really means that an examiner sits onto the application and reads it thoroughly in order to see if the patent application is valid or not. Now what happens after 12 months? You filed a regular patent application. Then after 18 months of the filing of the patent application, so it should be somewhere here, so this duration is now 18 months. After 18 months you get your patent application published. By published, I mean that there is normally an official gazette wherein the patent applications are published. So earlier it used to be a hard copy of Gadget, which used to be there in the patent office library. Now nowadays there is an online database available with each of the patent offices in the world normally, and there you get your patent application published. Remember that a provisional patent application is never published. It is only the regular patent application which is published. So this publication is really meant for bringing your patent application or invention to the public view. Now after this, the office action starts. So office action again is another term which is synonymous to prosecution. So office action or prosecution are same. So this exactly means that an examiner at the patent office looks at the patent application and checks for its validity. This is what office action means. And office action also includes questioning by the examiner questioning by examiner to the inventor about how do you think that your invention is novel and should be granted. So these questionings also come under the office action procedure. And normally if everything goes right, you have your patent application granted after 36 months of the filing. So another 18 months from the point where it was published. So at this point it is granted. What does it mean? So granted patent means that your patent is now enforceable. You can legally enforce your patent onto others if you want to, or you can get a legal protection onto your invention only when it is granted. Granted means the examiner has checked your application for its validity and has found no other invention similar to yours filed before you filed your invention. So at this date, at the date of filing this one, the provisional application filing, before that there has not been any application which was similar to your invention. So, and after that, if there is anything which is filed similar to yours, then it is decided by the date of first filing. So whoever files first gets the rights of the invention. And now after the grant, you have almost 20 years. No, it is 20 years from the date of filing. So after the grant, you have almost 17 years. Let me put it in years till your patent expires. After the expiry of the patent, you no longer hold the legal right for that invention, and now it comes to public domain and anybody can use your invention. So most of the earlier patents in microchip or microprocessors have now expired, which were held by Intel in 50s and 60s, and they are expired now, so they are in public domain and anybody can use those patents to design their own chips or processors. So similar is the case with other technologies. So this is how this whole patenting process works.